Hello and good afternoon, everyone. I'm so sorry I can't be with you live, but I hope this recording all works. I'm thrilled to be able to talk about uh, mistaken consent in cases of alleged rape. So the claim I'm going to be supporting is one, in fact, I made about 15 years or so ago, um, but it's one I'm still very deeply committed to. Uh, but the reasons I'll give today in support of it will be really somewhat different from those I gave in my earlier article. So the claim I'm going to support is that if at the time of the sexual activity, a person, I'll call them person B, is mistaken as to a fact, and had they known the truth about that fact, they would not have consented to the sexual activity, then the law should say that they did not consent to that sexual activity. And that means that if A, the person engaging in the sexual activity, knew or ought to have known there was no consent, understood in the way I've just described, that could be rape or some other sexual offence. So to give a straightforward example, if B consents to sex with A because B believes that A is in love with B, and in fact A is not in love with B, and had B known that A was not in love with B, B would not have consented. And if A knows that, but nevertheless goes ahead with the sexual activity, that should then be a criminal offence. So to me, it doesn't matter what that fact is. It's enough that it is for B a deal breaker, as Doherty has called it. Just a couple of background presumptions I'm going to make behind my analysis. I'm not going to be able to fully justify these two claims. I've written about them elsewhere, but I'll just outline them as assumptions that I am making. So the first assumption I'm making is that in a case of sexual penetration, when A sexually penetrates B, that is a prima facie wrong which requires a justification. In other words, we can say to A, why did you engage in that sexual penetration, and require A to provide an explanation. Something like, I just felt like it, or it seemed a good thing to do, wouldn't be enough. They need to explain why they engaged in that act. And if there is no justification, then the act can be decided, all things considered, to be wrongful. The second presumption I'm going to make for the purposes of this talk, although in fact my view is a little more complicated than this, but I'm going to take it for today, that consent can provide that justification. And the consent provides the justification because it can give A a good reason to believe that A has assessed that the sexual penetration is something that B wants, that is in B's best interests. So in other words, it allows A to say something like that quote on the slide, which I won't read out, but I'll summarize. That essentially A can say, well, I can't tell whether the act is going to be, the act of sex is going to be good for B or not, but it's B's decision. And if B has decided, thinking of all of the evidence, weighing everything up, and they have decided that the sexual activity will be a good one, then I'm entitled to respect that decision. I'm not necessarily required to, but I'm entitled to decide that I will base my decision to go ahead with the sexual penetration on the basis that B has decided this is something that they want to do. And so that's the way that consent works, if you like. It enables one party to say to the other, I'm going to rely on your assessment that this is something that you want. So I'm going to make 4 different claims in support of my view. The first then, if A knows that B is mistaken as to a key fact, by which I mean a fact which they wouldn't have consented if they'd known the truth, then A cannot rely on that consent as justifying their act. And that's because it does not give A a good reason for believing that the act is in B's best interests. So going back to my previous example, if A is sexually penetrating B, and B is only agreed to the sexual penetration because they believe that A loves them, and A knows that. A knows that B would not be consenting if they knew the truth. Then A cannot use consent in the way I've just described. A cannot be saying, well, B has assessed this to be in their best interests, and I'm relying on that. So just to develop that a little bit more, if a doctor's performing an operation on a patient, then of course the doctor needs the consent of the patient to that operation. But in fact, in that scenario, if the doctor goes ahead with the procedure, they've got two reasons to go ahead with it. First of all, the operation is going to be a good one for the patient, or we'll assume that generally the medical treatment is going to be beneficial. It's going to restore the patient to health. And secondly, that this is something that the patient wants. The patient has consented to it. But with an act of sex, only the second reason can do the work. Someone who wants to sexually penetrate someone else hasn't got a reason based on their own assessment of best interests. So in other words, if A knows that B is mistaken, then they might think that B is relying on a key fact which it's foolish to rely on, or it's bigoted, or it's petty. But the point is, it's for B to decide whether they want to engage in the sexual activity. And if A knows that B has relied on a falsehood in reaching their assessment, A cannot rely on their consent. In effect, A is saying, well, B has relied on this fact that I don't think they ought to have done, that I think is petty, and I'm going to go ahead. But the whole point is, it's not actually A's decision to make. It's for B's decision to make. So where there is mistaken consent, consent cannot do the moral work that is required of it. My second claim is that if A is sexually penetrating B, then A has a responsibility to ensure they have effective consent for their act. And if they know B is mistaken as to a key fact, and they nevertheless go ahead with the sexual activity, it is a failure of their responsibility towards B. So this is a relatively straightforward claim, and it's of course a general claim that if you're going to do something to someone which has a risk that it will cause a serious harm, then you need to make sure as best you can that the act will not cause them serious harm. So whenever one person is about to sexually penetrate another, they are in a sense engaging in a dangerous activity, an activity which could cause very serious harm to that other person if the consent has not been properly obtained. So they need to take care of B. They need to make sure that the consent that has been obtained is a proper consent. So where A is using deceptions or pressure or manipulations or incentives, where they're trying to get the other person to consent, they're not taking care of them. They're going ahead and engaging in a potentially dangerous activity, knowing that any apparent consent they have obtained is as a result of, for example, a deception. Then they are seriously risking the harm to the other person. That when the other person discovers the truth, they'll suffer grievous upset. And there are plenty of studies on sexual fraud cases which tell us how harmed victims feel when they've been deceived into sex. So that's my second claim then, that a person who sexually penetrates another has to take care of them. They're doing a potentially dangerous act and must ensure that there is proper consent. Thirdly, I think many consent cases we can see as conditional consent cases. So where there is a deal breaker, I'm only consenting on the basis that fact A is true, we can see these as, in effect, conditional consent. I'm agreeing to have sex if you love me. I'm agreeing to have sex on the assumption you are a fellow environmentalist, as the example from the case law gives us. So when the consent is conditional on a particular fact being true, the consent is only effective if the condition is satisfied. So only if you are a fellow environmentalist will I consent. It's therefore straightforward. If that condition is not met, then the consent does not come into being. And lawyers are very familiar with this, with conditional contracts and conditional gifts. So conditional gifts in a will, as long as condition X is met, then this gift is made. If condition X is not met, then the gift is not effective. And it's exactly the same with the condition. Notice 2 points about that. The first is that the condition can be the most trivial thing in the world. That's because it's a precondition. It's something that has to be satisfied if the condition is to come into effect. The nature of that condition that's put on the consent is irrelevant. The second point is I don't believe that condition needs to be manifested. So in other words, if A knows that B only agrees to sex if fact X is true, or if a certain condition is met, then A knows that if that condition is not met, there is no consent. The consent has not come into being if the condition has not been met. And that is just as true if it's within the mind of the victim or if they have manifested it to the defendant. So that's my third point, that many of these mistaken consent cases can be seen as conditional consent, that only comes, where the consent only comes into being if the condition is satisfied. So I move on to my fourth and final claim, which is based on the observation that actually many people discussing this issue agree in a way as to what the answer is, and that is that trivial mistakes do not count as negating consent, but significant ones do. But the question is, who gets to decide whether the mistake is trivial? And that's where there's a disagreement. Now, my view is that that should not be for the courts, nor for the defendant, nor for the jury. It's for the victim to decide what is trivial or what is not as trivial. And the reason I believe that is this, that there are many different views within our society as to what sexual penetration means. So for some, the act of sexual penetration is purely a physical pleasure. For some, it has religious or spiritual connotations. For some, it's an expressive act, communicating something to a partner. Perhaps for many people, it's all of those at different times in different places with different people. But what the law should not be doing is imposing a particular view of what is or is not important about sex. So if, for example, someone believes that it's essential that they are married to the partner they're having sex with, that perhaps might be a religious view. It's not for the law to say, well, whether you're married to your partner or not is a trivial matter, that that's not important enough for us to take into account. And that's because each person should decide for themselves. So the point is this: others do not have a right to touch us sexually. We are not required to give a good reason or an acceptable reason why we do not want someone else to sexually touch us. So if somebody has a condition that they'll only agree to consent based on condition A or B, you might think that's trivial. You might think it's prejudiced, but it's not really your question. It's for them to decide. And it's for them to decide because you do not, in fact, need to give any kind of reason why you don't want to have sex with someone. No one has a right to have sex with you. You're not required to come up with a good enough reason for why you don't want to have sex with someone. And we recognize this when it comes to fraud. We realise in relation to fraud that whatever the matter is, if a fraud is used to obtain property, then that can be a criminal offence. There's no suggestion there it cannot be trivial. So we need to recognise in our society there's a wide range of religious, cultural and personal values. It's not for the law to say these are matters about sex which are really important and these are not, which is what the line the case law seems to be doing. Nor is it for the jury to say that. It's for each of us to acknowledge we must all respect each other's sexual boundaries, except that it's for each person to decide, using their sexual autonomy, what's important for them. And I think there's a real danger that the current approach taken by the courts is imposing a particular secular Western perspective of what's important about sex. It's showing a lack of respect for cultural and religious diversity that acknowledges for different people, different matters should be taken into account. So for all of those reasons, I return to my conclusion that if at the time of the sexual activity a person is mistaken as to a fact, and had they known the fact, the truth about the fact, they would not have consented, then the law should find that they did not consent to the activity. If somebody knows that their partner is only consenting based on a mistake, and nevertheless they go ahead and have sex, saying to themselves, it's a good thing they don't know this truth, because if they did, they wouldn't be consenting. They are showing an utter lack of respect for each of our precious sexual autonomy. Thank you very much indeed.